Here's Mr. Woods. Well, he's waiting for this. Okay, yeah, I believe the only one that's gonna need, that's on is myself, Mr. Wood, court reporter. I hope they can hear me. You know how that,
I can hear you fine.
oh, good. We can hear you too, Mr. Wood. How are you doing?
I'm doing very good.
Okay, the judge,
Is it cooler where he is?
I wouldn't call it cool. The wind's blowing and it's not 100% humidity, so that helps.
When at 6 o'clock, they tell you the heat index in Galveston is 98. It's just warm.
can you say something else, Mr. Wood, please?
Sure.
Can y'all hear me?
I can say all kinds of stuff.
Oh, wait, we're not on, are we on the record?
No, we're not on the record. In fact, I'm gonna go for a couple things before we get off the record.
Okay,
We'll make sure we- Sure, then.
yes.
Sure, we're having to change the header on the default judgments because it should have said AP and Mildred Leonard's versus everybody. We didn't use the adversary header, so I'm trying to get those to her now. I'm not sure.
Okay.
Okay. What they come in there? It still hasn't come yet. Where are you? So I'm having trouble getting those emails apparently to her. Hold on. So we're delayed a little bit. Okay. You need the. Watch that copy of. Yes. You can never see front beneficiaries. Filed by Jane D. Nathan. And then by your other one. You got the designation specifically. You're good.
No, I think she can hear. I can turn it up some more if we need to.
And so you're gonna do. And then who was the other person?
Paulette.
Yeah. You want my copies of what you get?
Yes, ma'am. I didn't bring that. I mean, I pulled it out somewhere, but,
You
that's all right.
got,
That is each trust.
no, you can pull it out. I just can't. I'm fracture here and sprain here.
I'm gonna get it out.
Here, no, here it is. And then the other one is on the next tab. Opening a binder is just. What the hell can we do? I can't wait more. Oh, good. If I can help. So I'll get her change the vote one way here. Okay, let's see, I go back for more x-rays on the 26th. Who am I supposed to give to the nurses? The pleadings on the new phone number?
I guess that's gonna be us, right?
You want me to make a list as well, or those, we just actually pulled them, because in my county, they want you to give them. You
Well,
don't have
you're
to
in
send them
Bear County.
again. Yeah, I know, they're crazy, so
They're backwards.
I figured it's faster if you want it, but those are all the pleadings that need to go into the B number.
B number, every time.
Plus the orders that I'm gonna sign
Yes,
today.
plus the.
Okay, perfect. Yeah, this is not.
Okay,
So this is.
and that's Terry,
Plus
Mr. Woods'
that.
pleading is in there as well. Somewhere. Let's see.
Turn the speaker back on. Where he can hear us.
Terry's pleading, yes, this is it. This is, this is,
I'm not-
yeah,
okay.
so that's for the petitioners and the defendant, Mr. Yeah, because he sent me the one he made.
Okay. So I'll be going B.
Yes, ma'am, and FJ's estate.
Plus what we're gonna be signing today.
And that's it.
All the orders that are gonna get signed today.
Yes, and that's all that goes in B, right?
Yeah.
Yes, ma'am.
Okay. We're gonna be busy.
I'm here for you.
You gotta reference each of them.
Tell me
Format.
later what you want me to do.
Make a notation, but I'm gonna say, devising trust benefit.
Do you need any of this?
Spot 5, to say Jane filed that date, that time,
Okay.
and then I'll do the same thing
Yeah.
with Paulette. Okay.
Is this
Okay.
gonna be your stuff, Richard, or
Yes, I'm
Mr.
gonna add
Baker?
the 2 things to put in B,
Okay,
and I'm gonna rewrite this,
okay.
so I'll be over here quiet. I hope.
So did it print out? Oh,
She's
She's working on it.
and then he's got the exhibits that get attached.
It didn't go here, which y'all.
But before we call the case, I'm gonna go over a few things.
And I don't have the adversary style in here for FJ's.
Here,
You have a copy of that? old
Yeah.
one? Sorry. It looks like all of these we did wrong.
I know,
He can get it,
I
Christie.
know, it's been driving me crazy.
Mm,
Let me see which ones I have to tell her to get.
I think just. Because I was gonna say, oh, take it from my.
Did y'all come in last night?
Yes. mhm. Okay, well.
Is it 3986 I want?
FJ.
3986, yes, it's FJ.
39.
Just let her have that.
Okay.
P0 3986. This is gonna be big, once we get it established.
Anyway,
But you said you had other changes. right?
yeah, there are gonna be other changes.
All right, then I'll do that.
Let's, okay. So, have they, has that printed yet? What
Uh,
she needs?
Are you still working?
I've changed the style of the document. I was gonna show it to Ms. Moore, make sure.
Okay,
Yeah, the style was the only thing we needed changed.
We may have changed the pagination though.
I'm so glad Marangeli was here today. I'm happy Marangeli was here today too. She's awesome.
I was supposed to say you did.
Huh, Kate? Yes.
But-
Well, we think Kate's pretty awesome too. They're hard to come by.
Well,
The court reporters.
I know.
I encourage,
know,
if you don't know
Every
what you want to
time we have
do,
a Meeting at OCA, I talk about the problems with court reporters and why we don't have any and why it's such a problem. And Judge Herman finally met someone in Austin who, as long as they could be done on Zoom, she would do it. And she wasn't, she would charge $100 a hearing.
wow,
And that's, you know, as long as it was an hour or so hearing.
right.
Because in
Yeah,
the
we better
case
put-
in Gonzales County,
That's fine. Center bottom line.
we were paying 600 and something for our 45-minute hearing.
Yes, please.
And the court reporter was at home sitting in her house.
Your Honor, do you just want one copy of this default judgment?
That's all we need, unless y'all want
One.
one for y'all's records.
And with the shortages, they can almost get one.
Do you have a hand stamp?
Yes, ma'am.
But all I'm gonna want is a copy of the first page in class and see.
I knew I'd never make it. Not for me. And then I was tired, my secretary. said, Just retired. Somebody cut my arm and leg. Yes.
Does anybody need any water or anything?
Yes.
Where's Mr. Wood? Can you see this?
Let me see. Raise it up a little bit.
Change the header.
Okay, very
Oops,
good.
Sorry, got it?
Got it.
Here you go. That's it.
Okay, and we have to get exhibit A and B to Scott. Mr. Baker has them there.
Hey, thank you. These are all of the prior orders.
That's the way the order incorporated.
Yeah.
It's exactly.
That's the letter. Thank you. Woo.
Do you have water? Yes, ma'am.
I have water.
Right.
Would you like water,
Coffee?
coffee?
Water.
Coffee?
No, water's good. I get coffee, I'll get more energy.
Okay, before we call the case. I want to go, we've been talking about one thing here, and that's why when it's a lawsuit, you have a plaintiff and a defendant, and your style should always match your cause number on everything you file. Otherwise, clerks have a hard time knowing what, and let's face it, without the clerks, we can't operate. They are very important to us. But we all need to, and also we need to remember that when your staff is sending something, and if they're sending it service only, it's not gonna get file marked. And it's not going to be as part of the official file. So that's why we were having so much problems with the agreements and that not being part of the file. Because when they were sent in, the service only. So, and I know that my son's an attorney and he says, Mom, you're too much of a nitpicker. But I tell him that he practices PI law and they don't have to be nitpickers, but we do in probate. And so it's important that we get that right, because it really messes up the court's records when, and it takes more time for people to know what's going on. When you get back to your office, I want you to look up Texas Rules of Civil Procedure 239A, which deals with default judgments. And, you know, when I said the orders, the addresses have to be in there, actually what that says is that you are supposed to provide that to the clerk and certify it by the clerk. So I'm going to ask you on the record about the certification. And there was a change made to that rule in May of this year. And but the change is mostly on the clerk's side. There's stuff they now have to put in that notice. Some of it in Spanish. That has to go out to everyone. And I would think that you can mail for both notices, because you're going to do one for each case.
Mhm.
But I think you can mail them in the same envelope.
Okay.
Okay. Most of you don't have any trouble with Texas Rules of Civil Procedure. I mean, Texas, the Civil Practice and Remedies Code, section 30.014, because that's the driver's license and social security numbers which if you've been working in county courts all these years, you are in district courts, but it's now in statutory probate courts also. But here's one that there is a big problem with, and that's Civil Practice and Remedies Code, section 30.015, which says, in your initial pleading, you are to provide to the clerk in your pleading the address of your client. Now, that may not be important in other courts, but in probate, because we judges do stuff on our own motion, and because there's case law that says in a lot of things, notice to an attorney is not effective notice for their client. So the client has to also get notice. We've got to have that in the court's file. And if their addresses, and you can't use a PO box, if their addresses change during the course of the case, the clerk's supposed to be notified that. And I can fine you $50 if you don't do it. And when I was on the bench full time, there was a blank form sitting on my desk. And if it wasn't in the file before you left the courtroom, it got filled out. So that's so very important. It's very important in district courts and that, but it is in our court. So this is, we're gonna go on the record now.
Or do you need your notebook back?
No, okay, because we're gonna be on Edna right now. This is cause number PO 3846A. AP Leonard's and Mildred Leonard's versus WJ Billy DeVillier. How do you DeVillier?
We say the billiard.
DeVillier. And Paula Windsor individually and as independent co-executors of the estate of Edna Mae Leonard's deceased. There has been filed a motion. It is my understanding that y'all have been to mediation, reached a settlement, and there's been filed a joint motion for entry of a default judgment against Devasees who failed to attend mediation and for approval of mediated settlement of 3 months and entry of dismissals or judgments in conformance with such agreements. Ms. Moore, do you certify to the court that the addresses shown in the default judgment against Devasees who failed to attend mediation, that those addresses are, to the best of your knowledge, true and correct?
Yes, Your Honor, I do.
Okay, thank you very much. And has everybody had a chance to read this default judgment against Devasees who failed to attend mediation, approval of mediated settlement agreements, and entry of dismissals or judgments in conformance with such agreements?
Yes, Your Honor.
Yes, Your Honor.
And Mr. Baker?
Yes, ma'am, I'm sorry. They could answer, they know, yes.
Okay. And are y'all asking that the court approve these agreements
Yes, Your Honor.
Yes, Your Honor.
in
Yes.
the fall judgment and the judgments in conformance with the agreements reached?
Yes, Your Honor.
Yes, Your Honor.
Okay. I have signed this and I'm giving it to the clerk for her to file market. And there will have to be a copy of this put in the A case and in the B case. And also, Ms. Moore, you have an exhibit you need to give to the clerk, to the court reporter.
Yes, Your Honor, but there's not a B case in Edna's. It just stays in the A
Okay.
case. The only one that.
Oh, okay, all right,
Mr.
okay.
Yeah, I do, Your Honor, but I only have one copy of the exhibit with all of the green cards attached. This exhibit was prepared in my office under my supervision, showing that we tracked it when we sent the notices required by the courts. First of all, we sent them all regular mail as well as certified mail. None of the regular mail came back. So I think I wanted that to be made clear. But there are some green cards attached, and also my secretary did some United States Postal Service tracking, which you can do, and it still shows when it's delivered. So this exhibit really needs to be made in both the states, but I unfortunately only have one. The court reporter might be able to duplicate it for the second state if possible. I would like to
Yes.
offer this. This was, as I'm saying, this is the list of the devisees in both the states. Okay, it starts with FJ's family, then it goes to Edna's family. But because so many of them were the same, we did it all on one. So if we could mark this one as exhibit 1 in Edna's estate.
And it's admitted,
No objection.
it's admitted. And then we'll need to make another copy. I'm sorry, to put in FJ's. And all I'm gonna want is a copy of, did the pages change?
You just hold on.
I don't need a copy of the exhibits, just the order.
Just the order.
Yeah.
And you say just the first and last page or?
Well, unless the pages change.
On the judgment.
Did they on the
I believe
judgment?
they did.
Okay,
They
they
put
did-
page numbers
yeah.
on it. So
Yeah.
Yeah, so just give me a copy, after you've done the file marking, give me a copy of the order only. You don't have to give me a copy of the exhibit.
Okay.
And then they'll tell you what they want. And this officially closes PO 3846A and obviously 3846 also. The court case.
Mr. Wood, is that correct?
That is correct.
Assets in Edna's estates been transferred out? I
That
know
is
the
correct.
reason I'm asking is, as part of leading up to the mediation, there was a question about some mineral interests that had been gifted to Mr. DeVilliers by FJ when FJ thought he owned it. Mr. DeVilliers had deeded that back into the estate of Edna to the 2 independent executors. It's my understanding that Mr. DeVilliers is going to get that back, but I don't know if that deed's been executed. So that needs to be done to make sure all the assets have been distributed. Other than that, Your Honor, I believe all assets were distributed in Edna's estate per the settlement agreement.
Well, basically, you never really close a court case, but for our purposes, what we're doing here in the courtroom.
Yes, yes, Your Honor, that's correct. I just want to make sure we.
I can after 30 days after that has been signed, I can transfer the files back.
I think you're safe doing that. And that would just be in the court case, Your Honor. That wasn't, that was just an asset of the probate.
Yeah, and it's not anything that requires court supervision or approval.
Back.
Wait.
I'm sorry, what'd you say, Mr. Wood?
I said it's not anything that requires court and supervision or involvement in.
No, that's correct.
Right. Okay. Now, on FJ's, we have to change the style. And then my copy's over there.
Hold on, it's just the same as it was in hers, only,
The number changes.
yes, and go ahead. The, and the default judgment in FJ's is in both cause numbers, so I'm gonna change twice here. Is there anything else in the,
Yeah,
Okay,
there's
let's-
one thing that I'm looking for it. It's hard when you can't maneuver with all of this crap on your hands. It's on the one that does the severance. That there's another change that has to be
I
made.
have to change the header on that one as well.
You have to change the header, plus there's a place in there that something needs to be changed.
Is there anything else in the default judgment, Your Honor? That's what I was,
Well, we need to do the severance first, I think.
yes, ma'am.
Okay. On the bottom of page 2. In the severance one. And the reason we do that first, because it talks about the case that was severed. Right,
So I have to change the style at the bottom of page 2.
yeah, see where it just says the estate of FJ Leonard's,
Yes, ma'am.
cause number 3986B.
Okay.
I'm gonna turn him back around.
Well, that one,
You see her? He's,
So you will be changing that in,
yes, I'm gonna change this. As soon as I get to it, I'm gonna change the style. And then that,
and you don't have to put the. I don't know why it says. Well, it does have the, it doesn't really have to have the B up there. Because on the style, because the B hasn't been. Doesn't
did not.
exist yet.
okay, you did not want it in both cause numbers. I think we just did that in case you wanted it in both.
Yeah.
Cause numbers. All right, let me see if I can find the final order on signature. We had a lot of order. Hold on.
Well, we got a moment now, pro.
Here it is.
Break my paper.
So delete the B.
on both separate order.
You want me to give that
To the
to the
clerk,
clerk now or at the time of severance?
doesn't make any difference as long as she knows it's severance.
This will be part of the,
Severance.
just make sure you scan and put that in their file somewhere.
That's what's gonna come out of A into,
B.
Yes.
Okay.
So that when I file an A, will be now be filed in B.
in
Okay,
both.
Correct.
so this needs to be an A and B. Is that what
It'll
you're saying?
stay in A and a copy will be put in B.
Correct.
Okay,
Yeah, the new digital page, I decided everything is an original.
And I apologize. I realized last night when I was working that a note I had sent to you had a wrong statute number. It said 3.15 and it should have been 30.15. But it's really important in probate that those addresses be in your original pleading.
Makes sense. I always like in probate, like bankruptcy. It's the house of this.
Well, it's really not
it's something.
hard. If you have your book open and you follow it step by step by step. I had a county court at law, not a county court at law, a constitutional county judge in a small county contact me about something. And I said, well, I sent the email back, da, 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 da. And, the answer I got was, well, it sure would have been nice if they'd have said that in the statute. And I said, well, it does. And then I quoted the statute in the beginning of that chapter. And I said, you can't read just one thing. You've got to start at the beginning and read through all of it.
I can't.
That's, as a general practitioner, I don't have to explain to people. Probate is an end rim, it's like bankruptcy, it's an end rim in large measures. The relationship, one relationship is property,
I'm gonna have to.
not a
Because I can't,
traditional call
I
back.
can't get this.
Do you still need your card?
Yeah, I can't get it to line up the way it's supposed to. But let me go ahead and make that other change first.
I
just can't get, I
and
can't,
it is nitpicky,
can't get the.
but not overly, so. But the judges are nitpicky because one, we're the only judges who have personal liability. And,
You have to have a bond.
oh yeah. We have to have a bond. And, if we screw up or we don't do our job and call everybody's attention to things that are done right, we're liable.
Okay, so I,
But we're all also protecting predators and heirs and beneficiaries and
Provide a relationship to the property. And rent, right.
And I know that, in small counties like this one, there's a lot of things that the clerks hit for the first time. When it's a big enough estate or it's been messed up enough and one of us statutory judges come in but it's a learning experience too.
especially for us, really is
Sure it is, yeah.
a good thing.
Yeah, because this was the first time you'd ever dealt with deposition by written questions, right?
Yes, ma'am. Well, we've had them file, they used to be,
Well, there is still a provision in the decedent's estate part where you can do deposition by written questions to prove up a will.
yes, and we have had that, yeah.
But this, you contacted me and you want to know if you need to post it. You
Yes,
don't need to do anything. Which is
because I
fine.
was, when I first came, I was taught you posted those along with the questions, and she informed us we didn't have to. I had another question for her too.
And this is the first time you've ever had a severance.
Yes, ma'am. Well, yeah, in this case, yes.
I just can't get it set up right.
Actually, can I help them?
Oh, I had.
It's
So it's supposed to say.
So
in
we-
case I'm assigned to, and Gonzalez also had a severance. And then it had,
Let me bring that. Hey, may I have your notebook, Your Honor, for the FJ style? Sorry.
Dan, somebody's going to pick it up.
when you fund it together.
Because then I'll send her.
Did
she'll
you
also
want a
have to
copy
do
of
it
the
on the other
whole
one.
thing? Of this, are you gonna want a full copy of the default, both of you? Okay,
I just want the order.
Yes, ma'am.
No,
yeah,
I'm talking
no, I
about-
don't know if it gets scanned. I'm sorry.
I just want the order.
Yes,
Wait, let me give this, can I show her this one? Because it's the same. This is the style.
I think it is.
do it different.
You don't say you're not.
I guess I'm gonna be more.
PDF, don't we?
When I pull these orders off on the website, they want TI.
Really? Usually it's PDF.
We do that OCR. I think that changes on.
So I converted it to PDF.
Here, you wanna hand this to? To.
Oh, okay.
Oh, okay, stuff that on here. And then I'm gonna send you another one that's gotta get revised too. And it's gonna be two clause numbers, so I'll send you that one right away.
Like Charles.
So she's fixing the order of severance, Your Honor, then while we're talking about that one, I'm gonna send her the other FJ order, which is in both clause numbers. And have her fix that one, because I can't get it centered right.
Oops, 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 oops.
Let me make sure I final.
I'm on the bench.
Final. Mhm. And then actually I have one more order too on that one I need to,
Yeah, the
the
one that
that's-
starts with default.
Yes, but we also have an order that I haven't, we just got it finalized. I sent it to you as 2 pages. I'll show you on there. Part of the agreement was that we would go ahead and have an order entered on, in the event that the, rest of the settlement agreement wasn't complied with, that order gets held by the mediator. So I have one more order for you to sign today. It
But
recites all
do
of
I
that.
sign it today?
Well, we've designed it where you can sign it today, because I know you
Okay.
wanted to get rid of, you were thinking you might, and it's basically says that in the event, then this order gets entered, but it's gonna be held by the mediator. I'll let you see it and just.
Yeah.
That might,
If that was sent to me, it was after.
it
I
was
left.
not, Your Honor, because we didn't get it finished, it was one of the last things we were trying to do. And that's sort of what happened. So. Did you get the default judgment when you do, you would duplicate that twice, that would be good, and you can go ahead and print out several orders that you just did. And what you wanted it to be. Okay.
I don't know how to do them. Steve,
If you feel it's not, if you feel that we shouldn't do it that way, we will
well,
then
we'll see.
submit it later, but we tried to cover that. To explain what was going on.
I haven't figured out how. They insisted that I either had, if I'm going outside, I either had to have my phone with me or have on a watch where I could make a phone call. So the kids got me an Apple Watch, but I haven't figured all this stuff out yet.
I was gonna say, how do you like it?
I haven't figured it all out yet.
She can help you.
Yes. I mean,
I sure can.
it's too too much for this mine and,
Me too. I paid a lot of money for something. I don't know what's going on.
uh, because it's this last fall that I had, I was outside and in the backyard where, you know, you could call up, nobody would hear you.
Yeah.
And so I had to maneuver myself into the house by pushing myself. So I could get to a phone to call for help. Mhm.
One of those necklace things, that was button alert.
Yeah, I can do that too.
I did that as a college job in the 1980s. Guy came up with technology in Austin. And it was a real good college job until you had more, you know, but you monitor all the data processing areas. And it's quiet, and all of a sudden everything breaks loose. So you got to call 911, you wait
Yeah.
before they had 911. And but it was pushing over our security system.
Well, it took me over an hour to get myself into the house when this happened.
I think you can.
So I got fracture here, sprain here.
You don't bounce anymore, do you?
All right, I think she's got everything. We're just waiting whenever she's ready. So she should have the severance first.
Okay.
The last email that was sent hasn't come through yet.
The one on the order of severance.
Yes, ma'am. I know, the system is working super slow.
That's true.
So I've actually sent you 3.
I got
After
the
the-
one. the
okay,
one
but-
we worked on.
All right, so there's 3 more coming. You want me to try to resend it? That's the one that had, well, that was the one that had you saw it was like in boldface and you were gonna fix it. No, that hadn't come in yet.
I did the default judgment that, Ms.
Right, on
Brandon does.
Edna's.
Yes. But I haven't gotten any more emails. I'm so sorry.
That's okay, here's your free order of severing.
So keep reading.
Yeah, this is the one that I tried to do.
Don't feel bad.
I just can't get it's probably, I knew I,
You know, I
I
had,
knew I could not cut it as a secretary. Seriously, I mean, it was like, I just knew that wasn't gonna happen.
I had-
I'm never gonna walk off and do something I can do.
when my letter to file comes up, dates over here, part of it's here,
Yeah.
you look at it on the screen, but when it prints out okay.
See, mine, I don't know. I mean, I usually just do the text and then I ship it to my secretary and she puts it, you know, and makes it look good. 'Cause if I try to do it, it just takes forever, you know. I'm not good at it. That's all there is to it.
When did she retire?
And I have, in the old Word Perfect that we used to use, I could copy, you know, put a paragraph here and move it over here and do all that. I haven't figured out how to do it in
is
Word.
harder for me, yeah. Okay.
I still use Word.
She retired about a week after we.
I think
settled it. Her
attorneys are the
mother
only
needed
people who
some
use
care,
Word
care,
Perfect.
and so she had promised us, well, if we don't sell one, she said she'd stay through the trial, but once we settled it, her mom needs her care.
That's-
But she was ready to retire. We've been working together 30 years, it's no secret. You know,
She's family.
yeah, it is. It's horrible. I'm like.
And I
totally
can't
freaked out.
work on a flat,
It's probably a phone call.
like on a
away.
laptop
Yeah,
with that.
but
I
I'm
can't
trying not
use
to
that.
bother her. You know,
Me
it's
either.
really hard not to.
Typing like
keyboard.
that, yeah.
You just sort of really try
usually-
not to.
I have attached to my
Do you have
laptop
someone else in there with
an
you?
ergonomic
Yeah.
keyboard, because that's how I learned to type. And I don't ever use the numbers over here. I go up there.
We haven't gotten.
Well, it's a 10 key,
Did you get something, hon?
but it's still so much faster for me to go.
Maybe we ought to do it here and then can I send it
Because
to your
that's how I
printer?
learned.
I will be able to send it to the printer.
Typing, learn how to type,
So this is the one that.
all in family live, learn how to cook.
No, we'll say the default judgment.
Were you the,
Way
on-
of getting it
were you the only
I think it's just.
male in that
Really
one?
I think eventually I will get it.
We can change it on your laptop.
Well, when I was in school, of course, this was way back in the fifties, there was only one male that took what was
This
called
one-
homemaking in
This
that
one's
time.
up if you want to change.
Hey, I
This is the
took
part that
homemaking.
fell when I was- have a restaurant.
No, no problem. Do you mind if I take it?
No, go ahead.
Please, take it.
It was cracking.
And this is for Ken.
It's something we can use.
She'd be a good one to have.
So the typist in our,
Actually,
right.
trying to get rid of.
Well, you
It's
know,
gotta be mothers.
do you do real time?
Not yet.
See, I had real time all the time. It was on the bench.
Oh, and I bet that's hard to take away once you have it.
Oh, yeah, because you have to take notes. And it was so easy. And because I taught shorthand, I could read it without any problem whatever. And then it was so easy that, you know, in the evening or on Saturday, go in and be able to read back and make your rulings and that, because you had it right there.
The shorthand.
Like live subtitles.
Remember,
It's like
we
something
had to.
watching TV, but it's live. Nice.
But I could, you know, I can read theirs. And
I just remember
because basically it's just like shorthand.
the SAS. That's what? That's a
That's
SAS.
Yes, it just depends. I prefer to
all.
type the way it's spelled more. This is, that's the way my mind makes it work, but it's supposed to be phonetic.
This time of year, the internet's not moving very fast. She's
No.
Trying her best in there, but
We know how it is.
does it take that long all the time?
Not all the time, but periodically, yes.
Do you think,
Who do y'all have for internet?
Wind strength. Now with the county, I don't,
thinking it's on the string?
Is it?
Yeah, he was.
Never heard that one.
Kind of on my. Just what we have, and I don't brag about it. In Liberty, we have, you know, local companies, Liberty, internet TV.
Y'all don't have like AT&T and that kind of stuff?
They do it in Liberty, but not here. I don't use they keep waiting.
I use,
it's
I
probably
have
our internet.
Comcast and I
It's
have it
probably
from
our
TV,
internet. It's
cable.
full of-
It's my home telephone line, my internet,
Well,
and it's my cell phone.
yeah, I'm actually a member lady. I'm from Anahuac. You know, start our day, super practice.
Well, you're kind of located in two different counties.
And I live in the county seat. Are only 45 miles.
I know.
It's okay, I can hear you out.
Giving up, we're just gonna let her do it and then try to print it from mine. If we can.
Okay.
If it'll connect to the printer.
It,
That's the next.
Does she need to have that back in her book or is that yours?
the only thing I don't
But
have
she, does
Comcast
it go in
for
her
is
binder, the judge, or it's in here?
security system on your
Somewhere it
house,
has it.
and they could have that
That
also.
was probably your copy.
This is just a draft, I don't think.
That's mine.
Do you want, it doesn't have dates still in, so.
No, I know,
Well, I
but
mean,
it's still part of my phone.
I'm sorry, we did handwrite something on it to show her that we had to add the individually, but we got it, we're good.
That's quite all right.
Are you still with us, Mr. Wood?
He's muted.
Oh, he is?
I am.
Oh,
Just unmute himself.
Yeah, I was muted. Sorry.
I was checking your
You could
bathroom.
be here doing all this typing, Terry.
see, look,
Yeah, I kind of looked out on that, didn't I?
Where are you? Miss?
That's all right. I did my fair share the last few,
I know, we.
the last few days.
And then the judge is saying, I want this.
Okay. Get it right. Well, I'd rather have it right.
All right. You don't want to have to come back on this one again, huh?
No.
Judge Wood used to say, kill every cat in the house.
What did he say?
Kill every cat in the alley.
Judge Wood used to say, well, let's kill every cat in the alley.
Or the ASPCA one.
He was the school district attorney, old prosecutor.
Oh, yeah.
But he had a general jurisdiction court. In criminal cases, you were trying a case against him. You know, it didn't matter what the prosecutor, he'd make sure, you know, but in a civil case, he was kind of.
And I'm a nitpicker.
It pays to be that way in these cases. I agree with that.
Everyone that
Because
did-
these last forever. I mean, once you do these probate cases, people may look at them 25 years later.
I know.
That's a huge difference. And they transfer title, everything. So you've got to be really, I agree, you need to be more careful.
And in, you know, and a lot of, particularly the older attorneys don't ever do the executor's deeds and all of that. They just
Use the will.
use the will. And
We have a lot of phone calls about that.
Well, I'm on both sides of that. If there's sold devisee, I don't worry about it, because I do most of the human titles on that anyway. But if there's multiple devisees, I do it so it shows that you're through with the administration. Done. I don't, the creditors, there's no debts. Because that's what I was having for
Is she gonna yell? at you?
but, you know.
It's got her
You gotta
elbows
show
up
you're
and
through with
head
the
down.
administration somehow.
I think she's trying to figure out how to send it to your friend.
why do you do most of the amendments?
No debts, and it's so simple. You go to court one time, pass the title, no debts. And it's, I love it. It's predictable.
She's formatting it to.
I
try to
was
say that the
recently
people
the name of the
have to-
executor. And it really, all that was in there was the house, but he'd been in the hospital for a month, so you had to do the loan, do the whole thing, because you had all these, and it takes forever.
Yeah, you
The-
gotta make sure there's no debts. That's the
Yeah.
problem.
And
I do
even
have a
before I could
question.
put the house on the market, I had a buyer
Yes, ma'am.
for it.
I have a
come in.
question. I could ask the judge.
I'd had it appraised to do the inventory, and this person walked in with a earnest money contract.
Citations and probate.
Oh,
We have a case that some of the people that are needed served are out of the county.
You
Okay.
can ask, yeah.
Yeah, they're, okay, Judge Burwell, I just want to make sure we're right, but we have a case and people needing served, a part of them are out of the county, you know. it's
And
from
where?
Out of our county to
Uh.
be served, because we say by sheriff or constable to serve them.
It has to be shared. Only time it can be a private process server is out of state.
See, I feel like we almost have to teach.
In probate, in probate and guardianships, the only time you can use a private process server is out of state. I just sent an attorney a nasty letter
So,
who wanted a hearing and who had served a ward who was out of county by private process server.
Mhm.
And I just wrote a letter and said, I don't have jurisdiction to have a hearing on this.
Well, and that's what we tell them all the time, use the attorneys, but they did try to serve by a constable. And they were unable to,
Then they can do,
is it publication or?
no, they can come in and do the application for
106
6,
or substituted.
yep, or substitute.
And
But
then
they
they
have to
can
get a
do
court
what?
order, and that court order has to be attached to the citation.
Okay, I'm
do
gonna-
you know where they live?
Yeah, they've got the address.
They're just not answering.
Yes,
Posted on the.
so they can do that.
But they have to come in and have a hearing on it first.
Special service.
Your Honor, I have a question about that. Do you know what was the rationale for the legislature to kind of carve out that one exception for probate?
I didn't hear that.
I was asking, do you know what the rationale was for the legislature to carve out that one exception about using private process servers for probate?
Well, sir, it was way back when in the 1940s, when the rules of civil procedure were first adopted. And Rule 2 in the rules of civil procedure say that that any rules for service or that are currently in force are to remain in force. They're not changed by this. And this year, about 3 months ago, there's a 25-page, I believe it's 25 pages opinion by the Texas Supreme Court on a case out of Bear County.
Uh-oh.
Based on that administrative order between Judge Marion and Judge Spencer.
Oh, when they used to transfer them back and forth.
No, based on, you can use a private processor. And the Supreme Court says probate, guardianships, you can't change the law.
Yeah, that's, the rules of civil procedure only apply in probate matters to the extent it's not otherwise covered in the estates code. So you have to start there first. There's a special section in the estates code, so
Yeah.
you never presume, you always check it first in the estates code because it trumps the rules of civil procedure.
Yeah, I'm aware of it. It's, for
But
me, because I do a lot of civil litigation also, I just find that private process servers, you have a little bit more input in the process. So I was curious.
Well, maybe so, but unfortunately, I know that there's some judges around who aren't real particular about that. But I can, in small counties, there are. And I can tell you that there are a lot of void orders in a lot of cases in files in some counties. But I've always been one who made sure, and if it's serviced by a private process server, I have no jurisdiction. Can't do diddly squat.
And then on these, if they make application for alternate service, and she said you have to have a hearing. Do you have to have a
sometimes-
hearing, or when can the judge?
Yeah, you have to have an affidavit from the sheriff or whoever saying this is the number of attempts they made and all this kind of stuff. And then some judges will do it, on submission, some require a hearing.
Okay. That's what I want, usually
Gotta
are.
paper up why traditional service is not working, and then what would work. What it's likely to work.
And you have to have an affidavit from the person who was trying to do the service.
Right. Yeah, well, we have the return just showing their attempts.
Doesn't make any difference. There has to be an affidavit attached to the motion.
Follow the rules, 106, just like you said, just follow the rules.
I'll never forget being in the courtroom one day and this attorney, we were having an airship hearing. And it had to do with the change for
From the
married
person
couples, all children in one marriage. And this attorney saying to me, Judge, when did that change?
Oh, that's to the motion.
And I said, about 4 or 5 years ago.
You know what?
You have to pay very close attention when the legislature meets. And just like this change in the default notices, you know, I can remember when that was just a little card that was mailed. Now there's all of this stuff you have to put in there that if
It's a
it's for home or something like that, these are your protections.
Oh, yeah.
That would make sense. I would have-
The justice court, did you read that? That's where they do most of the debt collection. And there's new forms that are in effect right now.
I know, May the 1st.
Yeah, wow, this is, apparently this must be a bad problem with trying to solve.
Well, and what I thought was interesting that the notice that goes out has to have it in Spanish also.
Well, I think that's these three are
They get translation in the form. We did.
But, you know, it's
Big problem.
yeah, all these Supreme Court orders that are coming out are all having to do with debt collection, it seems like.
That's one of them, and it still has to be.
People all over other people.
Mildred Leonard, it has to have an involvement.
And this change was just
That's that.
a month ago, May the 1st.
Not done creditors and debtors.
what it needs to say.
You know, when stuff lows, no people's nothing, know how to treat it. Everybody.
Breach of contract. is too long. And- and that's all.
Great job.
Oh,
Yeah, you talk about
okay.
the-
Bless her heart, she figured out how to avoid the technical issues. So technical better.
I knew she.
Started out under a guy named Zeke Veronica, he used to say that every.
This is the agreed order on severance, Your Honor. Make sure I got the page 2 change that you wanted as well.
That every 2 years, the legislature repeals or it.
And it's, and Ms. Rain, you know that where it says sister, that's her
Yes.
title,
Right.
remember? She's a
Yes.
nun. You
Yes.
remember her being in court?
I do.
We
and I need
added
to
that
go back
because
and
there's
add it.
actually another Mildred in the family and we just wanted to double.
So
Make
they're
sure
two
that,
separate.
yeah, that we have but there's only one nun. It's just the 2 Mildreds though.
So
so-
Mildred with AP is sister.
Yes, ma'am.
And she's in her 90s, isn't she?
She's 93
Oh, wow.
and he's,
And now she appeared in court.
she's still both sharp.
Okay.
In fact, before the settlement agreement, I said I would like you to go to your doctor and make sure because I hadn't seen her for 2 years because of COVID and
Yeah.
I knew she'd had some issues and I said, I don't mean to be weird, but just so nobody worries about it, would you do that? She was. She said, she's good as I am. So I was like,
My mother-in-law is 96.
Well,
Miss Raymond, I tell you, she's,
Their brother
She's sharp.
FJ was their brother, died at 98, almost 99. So the whole group, she said a couple of them died young in their 50s or 60s or something. And then other than that, they're all just hanging out there. So
wow.
In my mother's family, they all were late 80s or in the 90s. All her brothers except one died in their 90s. Her parents died in their 90s. Mother was 87. And my kids are now having to deal with their father, who is he's younger than I am. I think he's 80. And he has dementia. And his wife does too. And so my son said, that he hoped that he had the Onheiser, which was mother's maiden name,
Those genes.
genes, and not the Burwell genes.
So, Your Honor, that's the order 7. She's typing the default judgment order, and then the other order that I had to give you also, she's changing the style on that while we're talking about that.
Okay, all right.
If you're ready on the 7th.
I'm ready on the severance. This is clause number PO 3986A. AP Leonard's and Mildred G. Leonard's versus WJ Billy DeVillier and Paula Windsor individually and as independent co-executors of the estate of FJ Leonard's deceased. And here again, the parties went to mediation under a court order for mediation. And notice was given to everybody that was named in the determination of airships that we had in this estate some 3 years ago, I guess, already 2 years ago. And there's been a joint motion filed for entry of this judgment and for the severance of the and transfer of non-settlement related claims and causes of action, and for approval of the mediated settlement agreements and entries of dismissals or judgments. And so the court is going to grant the severance, and the number of the new the style will be the same as in 3986A, but this will be cause number PO 3986B. And in rather than transferring the whole case as is done in many times when there is a severance, the parties are ordered to give the clerk the information on which of their pleadings need to be in the severed case. And the court is going to grant that severance. Today's the 17th, right?
Yes, ma'am.
May I say something to Mr. Wood, because I don't know if he,
Okay,
Mr. Wood, the order of severance for the court's request, I took out the B cause number header, so it's simply going to be in the A cause number. And I changed at the bottom of page 2, it says it has the AP and Mildred Leonard versus Billy DeVillier et al., etc. as the style. So we conform those two things. Other than that, the order's the same order that you approved.
Very good. I have been following the conversation, so I appreciate that, and I'm certainly fine with that.
Okay, thank you. On the others, we're just changing the header, the style number to say AP and Sister Mildred versus your clients, and she's working on those two right now. I think we don't have any other changes on the default judgment, Your Honor. Okay, and I have
just to attach exhibit A and B
Yeah.
and to go through the format of offering the exhibits.
yes, ma'am.
Ms. Rain,
Ma'am. Christie.
and I want a copy of the whole thing.
Okay.
We just need one of this. We'll all get copies from you. And then here is the revised default judgment. The only change we made on that was changing the style of the top.
Right, exhibit A and B.
Yes, ma'am.
It's the order for,
Well, you don't need that. Thank you. And our here is exhibit A and B to the judgment. And in FJ's estate. One was Ferdinand. Oh,
Oh,
Ferdinand, yeah. Put me on.
Okay,
Should I go ahead and offer that exhibit?
please.
Your Honor, as part of the default judgment in this estate on FJ Leonard's, I would like to offer a second copy of the exhibit that we offered previously in this estate, which is a summary of all of the addresses that the notices were sent to the various individuals, what happened as far as we tracked everything in the certified mail. I will say that none of the regular mail came back. We have a presumption of regular mail service. And on the others, we did track showing when the green cards were received, and some of them we had to track through United Postal Service, but all of them did receive notice one way or the other. So I'd like to offer that exhibit to prove the note that notice pursuant to the court's order, ordering mediation was given.
No objection.
And you do certify that, to the best of your knowledge, all of the addresses shown in the order for the default are true and correct?
Yes, Your Honor, I have to count on Mr. Wood for part of that because I think he may have typed them, but when I reviewed them, they appeared to be the same ones that we sent. Those are the last known addresses to the best of our knowledge.
Your Honor, I will certify that as well.
All right. And the court is signing this default judgment, ordering the clerk to send out the notices for the defaults, approving the mediated settlement agreements made in the estate of FJ Leonard's, the entry of dismissals or judgments in conforming with such agreements, and this this judgment says that any other relief that is not specifically granted or dealt with this order is denied, and this is a final judgment in cause number PO 3986B. And the court is signing this order and giving it to the clerk to be file marked. And all I'm gonna want is a copy of the order, not all the exhibits.
Okay.
May I approach the bench on this? This is the last remaining item in the FJ Leonard's matter that is the in the A case. And what we did in that case is part of our mediated settlement agreement is that the second half of the settlement payment is not due until December of this year. And the parties have agreed that to try to expedite it, that if that we would provide copies of the judgment and also a copy of a non-suit with prejudice to the mediator, Mr. Cook, who's agreed to do this, to hold on to it. And once he receives notice, if the defendants make the payment, then he forwards the non-suit with prejudice. If they do not make the payment, then he files the judgment. So we had designed it to have the judgment signed but held in abeyance. And we recited that in the judgment. If you would prefer that we not do it and bring it to you in December, we can do it that way. We were trying to avoid having you have to come back down to do it, because we're hoping it's just a matter of, we're hoping we file the non-suit, actually. That's what I'm
So
hoping.
here's the only thing I'm concerned about.
Yes,
Okay, if I signed it, did anybody check case law to see if something I date today, if it's not filed with the court until little over 6 months later?
Your Honor, I have not. We tried to cover that because I don't think that's going probably has happened. This is sort of unusual. we did say, we did include a finding that basically said that in the interest of judgment and efficiency and conformance to agreement, you found that you should go ahead and enter it, but it was based on the agreement that he would hold it and not file it until that time. Mr. Wood, are you concerned? I mean, this is your client's major thing. We don't want a judgment filed against them if they make the payment. So is your preference to then wait and just have the judgment sent to the court at that time, or?
The more I think about it, I think that's probably the safest. Your Honor, as I related to Ms. Moore this morning, I had some conversations and some communications yesterday that would lead me to believe that this matter will probably be finally resolved, I would think, no later than September the 1st.
Right, so we're kind of.
So a lot of this may I don't foresee that we would have to wait till December. I would be surprised based upon the conversations that and communications that were had yesterday. So it may be just safer for us just to hold out for another 60 days or so.
I think it's safer.
That's fine, Your Honor. We didn't know. That's part of the reason I didn't
Yeah.
send it ahead of time, because we were still trying to figure out if we could even do this.
I've never known it to be happening. I mean, there's not anything gonna happen between now and then.
Yep.
I wouldn't be getting to where I would be able to close it out before then. I got too many others. I've been working really hard.
No, I know you're trying to quit. I know. That was the other reason we didn't want to drag this out on you. Because we know-
Oh, I still have at least another year.
Oh, okay.
And I'm not sure I'm ever gonna get rid of the case in Gonzales County.
Well, they told me they thought it was gonna get done, so.
Well, they can't,
Not me, but some of the people in my firm. It's not my fault.
they can't find anybody to be guardian of the estate.
I get that.
Uh,
Let me just say one thing on this, Your Honor. The purpose of doing this is there's only one obligation under that settlement agreement, and that's to make a payment. So we did not want to have to file a petition that says they breached the settlement agreement. We agreed they could just we could have just a judgment entered
Right.
once the mediator confirmed it. So we will follow that, and then
it also refers to attachments.
I know, I have those too, Your Honor, but I'm just saying, but
I think it's safer
okay.
to wait. Particularly in view of the fact, all it would be then is a notice of dismissal or a default judgment. I mean, not a default judgment, a take nothing judgment.
That's why we're gonna do dismissal with prejudice, so you wouldn't have to worry about signing it. If we do a judgment, if there is a judgment that has to be entered, is there some agreement we can make that it enables you to sign it remotely where you don't have to travel?
Yes.
Okay. Mr. Wood, did you hear that?
I did, and of course, I'm totally in favor of whatever is necessary to do this as efficiently as possible, because either way, it's really more of an administrative action.
Then that's fine. Your Honor.
To me, I have a real concern about something dated today and not being filed with the court possibly for 6 months.
We did too. We were trying to figure out how to avoid that problem, but we're happy to do it this way, Your Honor. Particularly if you're still gonna be here for a year.
Oh, yeah.
You had told us the last time this was it, so we're saying,
Well, I'm not,
I don't want to have to get a new judge in on this.
no, it'll take a year before I finish it.
Okay, well, thank you then. Then we'll do it that way,
I'm
Your
not,
Honor.
I'm not taking any new cases other than accused.
Okay. All right, Mr. Wood, we will
And
do
I
it
got
that
two-
way, if
and I-
that's good with you, okay?
That's perfectly fine with me. I think, there's no chance of something going differently than what we envisioned this way.
All right, and the only other thing, Your Honor, is the mediated settlement agreement. Mr. Wood did file under a confidentiality notice because it was important for his clients primarily to keep the contents confidential. And you filed it that way. He said there's some way you can file it. Okay,
Yes.
so we think we're good there. All right. All right.
That's right.
You see it's
Um,
a document, but it might have been on something else.
It's the way it's filed.
Yes, whenever he files it, he has it to where when it comes in, it's filed, but the public can't do it. Right,
A rule,
ma'am?
it's motion something 12.
No, it's not really sealed. It's just
It's secure.
secured,
Yeah,
so all
that's
the
sealed,
parties
secured.
can see it. So it's
Yeah.
not like a sealing thing. It's just, a lot of times that's important to people that, they not have that revealed. And I think it was important to his clients and we're willing to, go along with that.
Yeah.
So I think.
It was, Joyce, are you going to get a copy of all of the orders?
I can wait and get that can y'all make,
Sure.
you don't
I
need
already
the,
got mine.
you don't need the attachments, do you?
No, I do not.
Okay, and then I've given her your pleadings for the BK. And, I think that's everything. I'll wait for them and then I will send it to you Monday, maybe.
Yeah, Monday's fine. Monday's fine.
All right.
The insurance companies has requested them.
Yes, ma'am.
Oh, the insurance company, well, you can attach the orders the attachments, because the orders do have attachments.
Yeah, I don't think they need the attachment.
Okay. Yes, I'll do that.
Okay.
And you got yours, okay.
I thank y'all for working this matter out.
Thank you.
And,
Thank you.
and I'm sure that Chambers County is happy that you worked it all out. Not because
But we still have FJ, right?
I will have,
We just have a tiny piece of FJ open. The A cause number, all it has is a settlement issue. We're hoping that's done in the next 90 days, so. That's it. The rest of it's done. All the big stuff's done.
Yeah. But I have to wait 30 days for the judgments to be final before I can transfer the files back.
Oh, wow.
So, but on FJ's estate, will you hold on to the A?
Yes.
Okay. That's, yeah.
I will hold on to the A. And, yeah, because no judgments are final until 30 days after signature.
True. All judgment.
That's the fat lady singing ruling. That's just the regular rule.
There was a very prominent bank in Galveston County who learned that the hard way.
Yeah, don't start executing.
They paid out some money on a small estate affidavit where actually the people, everybody who signed off on it had lied. And the person had a surviving spouse. And it wasn't until all her checks started bouncing that she even knew about.
Gosh.
But it was within the 30 days. So she got an attorney who came into court and we voided it.
And the bank had done the small estate affidavit?
No.
Oh, they just paid
They,
based on.
they paid based on it. And, it's just like they tell you in divorces. Takes 30 days before it's final. After the judge signs it, you can't go get married for 30 days unless you get special permission from another
To the same
judge
person again.
to get even to even get a marriage license. Did y'all realize that? If y'all issued the driver's marriage licenses?
Yes.
They have to answer that question
Yeah.
when they do that.
Raise your right hand.
Yeah.
Okay.
Thank you, Your Honor.
So you just need copies of,
Yeah, you can just make one copy of
Oh,
each
okay.
of the orders, and then when I get it back, I can make one.
but you don't
I gotta-
necessarily,
I can scan it and email it to him.
you don't need the exhibits or anything, or you
No,
do.
ma'am, I think we have.
You're just gonna go.
I can download.
I can email it to you if you want. I'll email it to Mr. Baker. You
Ma'am,
do that, I'll take them home when I get there and scan
Do
it.
y'all have all y'all's files on the internet yet?
yes, they should, but I don't know what our,
Once it's-
you have to,
filed, The orders,
they filed.
the
Yeah.
orders should be filed, right?
Yes, but they're, Yeah, and we'll scan them in there
Right.
now.
Do it as a PDF. I like it.
Ours is PDF. I don't fall in there.
I
under
think
TIF.
what he's, I
Well,
think,
I know your stuff that's been e-filed.
Yes, ma'am.
Can be accessed,
Yes,
but can your local ones be done, accessed through you?
they can't, they have to call, they have to register in our portal. And I don't make those, that other stuff, but if you register,
There's
if you're
two
a
levels of
party,
search, the way to
yes.
do it. You can get some stuff
Yes.
without registering, but you can't get all.
everything.
If you would still make me a copy, because I think.
You know, when we went to,
Make you a copy.
obviously, way back when I was,
They're all.
but we went to it in 2007 in Galveston County. And so when I would make my rulings, when it wasn't an order here, I would just type them in the notes. And the attorneys could access those notes and making the orders, and it was so nice.
Yeah.
In some counties, I still have to have a document.
Sometimes that's the only record. of what happened.
Uh,
Sometimes.
But like I was telling the court reporter, all the years I was on the bench, my court reporter did real time. So I didn't have to take notes during hearings or anything.
Your Honor, this came out of your notebook on FJ's estate. We also had a little handwriting on that one to show.
Okay, all right,
Thank you. I'm just waiting on copies other than that. Are you finished, Your Honor?
we are, you may be dismissed.
Thank you, Your Honor.
Karen, I'll get it to you Monday if I can. I'll get Mr. Baker's too.
That'll be fine. Everybody have a good weekend.
All right, you too.
You
Have a
too.
nice Father's Day, every father in.
oh, yeah.
Yes.
I will. I'm looking forward to it.
And yell for the horns tonight.
I will do that as well, Your Honor.
Win tonight, they play Sunday. And
We,
the Horns win tonight, they play Sunday.
on Sunday,
Yes.
On
If they win
Father's
tonight,
Day?
what about A&M? A&M plays this afternoon.
That's.
Thank you, ma'am.
A&M plays at 1, I think, today. And the Horns play at 6. And how many watched the game last night? You know,
We have one of her.
I never been a basketball person, but my daughter